Juliana has given us the thumbs up. Yeah, thanks to Juliana for getting us squared away here. No small feat. Our Tangibly's first LinkedIn Live. Big thank you to John Pryor for joining us and prototyping this format with us. Thanks, John. Chris, great to see you. Good to have you on this time zone. Down in San Francisco for an IP conference. So real quick, I just want to outline some of the key points that we're going to be talking about today. Getting started, like where are we? How in the world did we end up here? What are non-competes? Look a little bit about what's actually happening in the courts with respect to non-compete agreements. So get a little flavor for where things where things have been and where things are heading. Looking at what companies should do now, and no surprise, as a trade secret, a group of trade secret enthusiasts and trade secret company of Tangibly. No surprise that we'll be starting to talk a lot about recent trade secret law as well. And then again, I would love for this to be as interactive as possible. So anyone out there that has questions, please drop them in the chat. I'll be following the questions and can pepper them in as we go. Let me get back to this slide. Just a real quick background on Tangibly for those of you that don't know about the company. Chris and I got started in 2020 along with another co-founder, Liat Blinson. So we're based in Seattle. The team is all over the world. We've raised about $9 million to date, including that list of logos on the right. So we've got Madrona as our largest investor. Then we've got a couple notable law firms in DLA Piper and Wilson Sonsini, Wipro, and a whole host of stable of other really great seed investors. We're now a team of 22. We kind of balance between a bunch of IP geeks and machine learning and NLP experts. It's pretty interesting to see, a company of our size already with a pretty global footprint, which really quite speaks to what's going on in the trade secret landscape. So with that, maybe Chris, do you want to do a quick intro about yourself, and then we'll hand it to John, and then we'll dive in?
Sure. Thanks, Tim. So I'm Chris Buntel. I'm one of the co-founders of Tangibly and a U.S. IP lawyer for a long time, over 20 years now, which is kind of scary. And I still like patents and trademarks, but have come to love trade secrets. They're really the next big thing in intellectual property. So it's great to be here.
Yeah, thanks you very much, Chris. Thanks.
John, I got a slide on you. There you go.
Oh, tremendous. Yeah, thank you. It's funny, isn't it? I mean, it feels very much at the moment like all roads kind of lead to Rome. There's so many things going on in the world that relate to trade secrets. And, we're discussing today one key one, the erosion of non-compete. So very, very pleased to be here. I'm very pleased to be here with the Tangibly guys, because I think it's a very good product and a very timely product, and one that really meets the pain points of quite a few customers out there in the world. And I think my mission, our mission probably is to get out there and make more people aware and get more people engaged in good professional trade secrets management. Thank you.
Fantastic. So non-compete 101, let's just kind of get started and jump in. And so Chris, I'd love for you to kind of just take us through this. And at the outset, I'll just say, a big shout out to, Russell Beck and the folks at Beck Reed. There's a couple links here. And if you want to learn more, and again, happy to share this. This graphic comes from the Fair Competition Law website. And I just think it's great to sort of highlight the idea that non-competes have been around a very long time. But maybe Chris, you want to talk us through this and jump into the FTC, because I think that's what's driving a lot of interest in behavior over the last couple of years.
Sure, it really is. And it's been an amazing year for non-competes and trade secrets. It's always fun when the popular media, the CNNs and New York Times of the world, talk about IP issues. And this year it's been all over with non-competes. It's really a hot topic. And fundamentally, non-competes have been around a long time. They've just been kind of normal, or not much attention was paid to them. But this year, and even the last couple of years, they've really become much more controversial and much more relevant because the work world is changing, especially after COVID. A lot of work behaviors have changed, and that kind of made a bigger magnifying glass be applied to non-competes. And fundamentally, non-competes are a contract. It's a contract between an employee and an employer, and they really limit the movement of people. They're not designed expressly to limit the movement of information. That's kind of a side benefit. But it basically says, for a certain scope and a certain time and a certain geography, if you leave my company, you can't go work for a competitor, or you can't start your own competing business. So in some ways, it's really a competition restriction or a limiting factor on what your competitors can do as far as hiring your current and maybe soon to be ex-employees. And a lot of people feel, especially nowadays after COVID, that that's somehow fundamentally unfair, that people should be able to change jobs, feed their families, put their kids in school after they leave one job and move to another one. And that's really made a lot more public discussion and a lot more visibility into, are non-competes appropriate or not, and what kind of restrictions and limitations should the government place on non-competes. And it all came to a head with the FTC, from the federal government. But if you dig deeper, you'll see that individual states in the US and countries around the world have actually been on the attack for a number of years now. It isn't a 2024 thing. This has been gradually building speed, kind of like a snowball rolling downhill. And all the states and other countries are putting more and more restrictions on what can a non-compete do or not do, and how broad or how narrow does it have to be effective.
So, Chris, I think a couple of things. One is, and the way I've thought of this as this has become a much bigger topic in the last 2 years, is that really historically you could almost sort of think that a non-compete is like the lazy person's way of managing trade secrets, right? It's like, well, I'm going to control the person, and therefore I don't really have to worry, too deeply about, the data. And so I know it's an overly simplistic view, but it's, I think there's a little bit of truth in it. And then I think the other thing that you said is that really resounds with me is that it's really about, controlling the person as opposed to controlling the data. And I think, this new world, order that we're seeing form in real time is really about, where's the data, who has access to it, what is it, and some of those things, which we'll dive into in a bit.
And Tim, you mentioned it's kind of the lazy way or lazy approach. Yeah, as a plaintiff or as a plaintiff's lawyer, the story is actually very simple for a non-compete. So, did the person leave company A to go to competitor B during the timeline of the non-compete? And it's very simple. It's usually yes or no. And a plaintiff's lawyer would love it, because if you assume, for the sake of assumption, that the non-compete is valid, proving it is really simple. Did you leave company A? Yes. Did you go to company B, which you're not supposed to? Yes. End of story. So it was very simple compared to proving a typical trade secret case, which can become much more complicated.
Right. And again, just one of the other, I think, great things about this, the graphic and a lot of the content on this website is, we can all blame it on Jimmy John's, the Subway shop. They were shipping non-competes, to their franchisees. And I think it was New York and Illinois. The attorney general put an end to that. And so, that was probably the beginning of the end in the U.S. when the Subway shop was trying to get their workers under a non-compete. So Chris, maybe just walk us through the FTC ban and where that's at right now.
Absolutely. So the FTC ban was supposed to kick in on September 4th, so about 5 or 6 weeks ago, and it obviously didn't happen. It was immediately challenged, and in the Northern District of Texas, it was basically shot dead. And then a week or two ago in Pennsylvania, a lawsuit challenging that was voluntarily dismissed. So the situation today is, it can't go into effect. What the FTC could do, which is highly unlikely, is to appeal that Texas finding that it's unlawful for the FTC to have done this. They could appeal to the Fifth Circuit, but number one, it's unlikely. And even if they did, the chance of prevailing is super low because they would have to somehow show that the trial court got it wrong or violated some procedural rule or just did something way out of line. And it's not clear to anyone what that would be, like how they could complain. So it's probably just going to die on the vine. And instead of having a uniform federal rule, we're back to having 50 or so states and then other countries each having their own version. So it's pretty much dead in the water.
So let's just talk for a minute about the states, and I think this will lead us nicely into Europe and get some of John's perspective on what's going on there. So 4 states in the U.S. have a full ban. California is always used as the example of why non-competes aren't really needed. You have a very thriving technology sector in California. You have pretty much free movement of people from company to company. We have seen a big ramp up in trade secret cases between those companies where, again, 10 years ago, it was sort of free movement. Nobody really cared. And I think as trade secrets have sort of found their place in the world, you're just seeing more litigation. And so, and then what about these other places? So obviously there's the states with no restriction, so you can still presumably litigate non-compete. But let's go to these sort of income restriction, other restrictions. What's that mean? What's restricted exactly?
So Tim, if you look at the map, the first thing to take away is it's very much a patchwork of colors. There's very little uniformity. And a lot of states will have limitations on things like income or specific roles. But again, no 2 states are the same. So some of them will say for high income earners like senior executives, non-competes are okay. But for someone making sandwiches at Jimmy John's or at Subway, you can't enforce a non-compete. Other ones have exceptions. So like Rhode Island, where I grew up, has one for the medical field. So doctors and nurses are not subject to non-competes, whereas other industries are. But then you compare with New Jersey, and they're saying that psychologists and in-house counsel like myself are exempt, but they don't say anything about doctors and nurses. So like every one of them is different and they all kind of mix and match. It would be nice if there was more uniformity or again, a federal uniform rule, but that's just not the way it's shaking out.
Yeah, it's again, it harkens back to some trade secrets, but yeah, like it wouldn't surprise me if that's the direction it's going to head. Some like harmonization, minimum standard, perhaps. Yeah, it's interesting.
I think it will, and all the states had their own different trade secret rules, and then the UTSA and ultimately DTSA really harmonized that and provided a federal cause of action that people could take. My guess, and yours too, is that non-competes are trending that same way, just a little slower.
Yeah. So thanks, Chris. And I think, John, this is real. This patchwork, I think, is very much represented in Europe as well. So maybe talk a little bit about what you're seeing in the larger European countries when it comes to this topic.
Yeah, sure. Thank you very much. I think it's important to reference this as the UK and probably Europe refer to it as the post-termination restrictive covenant. And a non-compete probably might be referred to as a non-compete clause between companies, which again are under attack, vis-a-vis sort of monopolistic sort of practices, etc. But if you look at it from an individual perspective, an employment perspective, post-termination restrictive covenants, then the UK government's made a very, very strong statement on this. They're basically saying that they shouldn't be any more than 3 months. They're having a consultation around this. They're basically saying it's one of the biggest impediments to worker movement and potentially to innovation, and certainly setting up competing businesses, that people are restricted in their movement beyond a period of time. So the UK government is recommending 3 months. They haven't enforced 3 months, but they are doing a consultation period to move towards that. And within the government themselves, they are actually enacting that at only 3 months.
It's a funny number, right? Like 3 months. It's like what I just wonder where that psychology comes from. Like what's that really going to, what's it really going to do? You forget stuff in 3 months.
What's it going to do with regards to trade secret? Next to nothing. It's token, really, isn't it?
Yeah, token.
Sure. Trade secrets, and actually of interest, where there have been challenges. There are challenges to these. They are in, as you've said already, senior employee contracts quite regularly, but frequently, of course, there are challenges. And then when you look at some of the challenges that have gone down recently, you kind of get into the realms of, well, prove to me that he was exposed to confidential information, prove that it was actually confidential information, prove that confidential information had value, which just begins to sound to me very much like trade secret program and trade secret management. And if governments are weakening on non-competes, and then even if you do try and rely on non-competes, they try and push you down the road of, is it a trade secret? Is it confidential information? You may as well just go straight away to trade secrets and do what you can with the others. In Europe, it varies by country very much, but there seems to be an inexorable move against non-competes, the restrictions, for senior employees to a certain period of time. Financial compensation must be given. In certain countries like Belgium and Austria, they've been eradicated altogether for employees beneath a certain income. I don't know what the income is, but more junior employees. So there's an inexorable move towards reduction, erosion, and probably annihilation as per 3 months of non-compete. So in that sort of environment, what do you do? And I think the answer very clearly is you have to put together a trade secrets program to manage, identify, and protect your confidential, sensitive, and valuable information.
So do you see, and I've always kind of wondered this with these kind of things, do you see any, do you see companies trying to avoid, say one country over another for staffing reasons when it comes to this topic? Has that started to filter into anybody's thinking yet?
Well, I think the consultation sort of review that I've seen, the UK government has published their consultation, and a lot of companies don't want to lose non-competes, understandably. So I think it's interesting actually when they're talking about the company and they're talking about themselves as an individual. You sometimes get different results, of course. If I'm representing my company, then I'm going to say one thing, but if I'm representing John Pryor, I'm going to say something else, and that's certainly come out in the consultation and the review. But no, I don't think there's any particular I think Spain, for example, Holland, Denmark are leading the charge on some of the changes. I've just mentioned, of course, Austria and Belgium as well. So, and very tight compensatory requirements in Germany. 50% of the compensation to be paid through the duration of the non-compete to an employee, etc. So it's a clear recognition that the restriction has to be balanced out. I go back to that point earlier. The case that I was reading about, what was it called? It was called Quilter or something. I can't quite remember. Essentially you had to prove you had taken the steps and measures to defend that information, as you would in a trade secrets program management as well.
Yeah, I think that one blends nicely with the Shopee example that Chris is going to talk about. Well, so before we jump into the cases, real quick, Chris, I think you've always made the kind of point that a lot of these agreements tend to be like overly broad, and so it sort of strikes me as though when you're working with as much like nuance that's certainly in the U.S. state system or even the European system, country to country differences, like tightening up these agreements seems like it's, pretty important.
Yeah,
It really is, Tim. And if you want to use a non-compete going forward, it really is advisable to have it be tailored to the individual and to their situation versus how most people do it, which is just a standard template from HR that's ridiculously broad. There have been cases that said like a CEO in theory couldn't become a dishwasher in the cafeteria at the competing company because the non-compete was written so incredibly broadly. And, like I said before, it's scope, duration, and geography. And most of the time, these agreements are way too broad on, well, usually all three requirements. And it's really a good idea to think more carefully about tailoring them much tighter to have a chance of them surviving attack, if you want to use them in the first place. Like John mentioned, we're seeing a lot more kind of blurring the lines between non-competes and trade secret agreements, because as non-competes become less effective, protecting trade secrets directly becomes more important. So it's like one goes down, one goes up. And in places like California, where non-competes have no value, there's tremendous activity in enforcing trade secrets. So again, it's kind of a balancing act between the two. But at Tangibly, we always say that it's better to protect your trade secrets directly rather than rely on an indirect method like non-competes.
Do either of you guys feel or have experienced data that gives you a sense for companies' ability to sort of draw the parallel or the relationship between non-competes and trade secrets? What's your sense, Chris, on sort of the average company out there? Do they build that connection automatically, or does it still need to be taught?
I think it still needs to be taught. I think we're trending in the right direction, but they haven't quite made that second leap. Like they're as far as understanding that non-competes are maybe not useless, but unpredictable as to whether they will do what they are supposed to do when and if you need it. I think they're mentally that far into it, but haven't quite made that next big leap to say, we need to boost our protection of trade secrets because of the weakening of non-competes. We're not there yet.
John, what do you think? What's your experience?
Yeah, well, I just asking the question, what are you trying to protect with your non-competes? You're trying to protect trade secrets and proprietary information. You're trying to protect customer relationships, specialized skills or knowledge. Yes, goodwill or reputation, that the person's not going to badmouth the business, etc. And then recruitment of employees, sneaking the team across to join you, kind of thing. So all of those can, to a lesser or greater extent, also be covered by trade secrets. And there's nothing, most of the battles are tending to be around about that sort of information. Stolen the customer, moved the business across, taking the team, etc., etc. So it's governments seem to want to erode non-competes because they think it's an impediment to innovation and they want innovation. Companies, in my view, have to therefore start to look at other ways to protect the information that a non-compete would have protected. And it seems to me that all of the above could, to a lesser or greater extent, be protected with a good trade secrets program. Where people are at the moment is a good question, and I don't think everybody has quite, as we all know, when we're talking to companies all the time, they may say they have a trade secrets program, but when you start to ask, well, is there a register and are people trained and do you have a policy that's enacted, then the answer is quite different. But yeah, I think there's a sort of move in that direction, but there's still quite a way to go, I think, in many cases.
Yeah.
And John, I'd love to know your thoughts on garden leave policies. So for our viewers who may not be familiar with the term, the idea is after an employee leaves, you basically continue to pay them to stay home and to not go work for a competitor for 6 months or a year or whatever time. My feeling is they're not always useful, but in the right situation, they can be an effective alternative to a non-compete. But I'm curious what you've seen.
I think a lot of the restrictive covenants are moving in that direction. You're providing compensation, sufficient compensation. So, if they do have to be outside the workforce, then they can live comfortably, and there's no detriment to them. But the reality is, those relationships endure 3 to 6 months, 12 months, right? And whilst you're not meant to keep in touch during that period of time, you can see what people are doing on LinkedIn and so on and so forth. So I don't really see, that it's actually protecting a lot of what a non-compete is seeking to protect. The know-how and the technology and so on and so forth, of course, it moves on in that period of time. But the commercial aspects, those relationships are still strong, and I don't generally I understand exactly why they're in place, and I think European law is moving in that direction possibly, but I don't personally see that they do have much of an impact, because if you're talking about a Google search algorithm which is going to endure 25, 30 years or whatever it is, 12 months at home, and I know that Google search algorithm, well, I still know that Google search algorithm 12 months later. So it's not particularly answering all the questions, I wouldn't have thought.
And from a damages point of view, I think, you certainly don't see, multi-$100 billion damages around non-competes, right? We're now seeing them pretty routinely around trade secrets. So I think that, in many ways, is the most obvious bit of training, right? It's like, well, what would you rather, be able to accomplish if there were damages, like getting the damages, or, I don't know, an injunction, or getting a guy fired, or, whatever.
And Tim, usually in a non-compete situation, what the plaintiff, the former employer, wants is that injunction. Like, that's really the relief that they're looking for, is basically, this newly hired person should get terminated immediately and cut loose. It's usually not so much about financial damages.
Yeah.
But like John said earlier, there is this blurring where the non-competes are required to have a legitimate business rationale or legitimate business purpose. And almost invariably, that's trade secrets. So, if you look into some of these more interesting cases, they very quickly kind of shift gears into, was the employee exposed to trade secrets? Was the company protecting trade secrets? And suddenly the story changes from non-compete. So it's really interesting to read these cases.
Okay, so let's jump to a couple non-compete cases, and then we will dive into a little more trade secret speak. So Chris, I know you've done a little bit of work around this Shopee case in Singapore. Love to hear about that. And then I think you have a US case to touch on as well.
I do. So the Singapore one was between Shopee, which is a major online product sale company, conceptually sort of like Amazon or a little bit like eBay, against ByteDance, which is the parent company of TikTok. And there was an employee who left Shopee to join ByteDance. And the non-compete was super broad, like we mentioned before. And ultimately, it changed gears to talk about trade secrets. And there was no evidence at all that Shopee could share with the court to show that this employee ever contacted a trade secret, which is probably not accurate. Like every company in the world has trade secrets, like we always say. But the interesting thing is Shopee could not prove to the court that this person had anything valuable to take with them. And it really failed that legitimate business purpose to the lawsuit. And ultimately, Shopee lost. And it wasn't because of the non-compete so much as they didn't have a trade secret management program like John mentioned, or they didn't have a trade secret platform like Tangibly that would have given them the evidence and the proof that they'd need to stop this employee from moving. So it was a really interesting case and very quickly started to resemble a trade secret battle rather than a non-compete.
Awesome. I think that says it all.
And Singapore's
prove it, right?
Singapore's interesting. There isn't a trade secret specific statute,
Right.
but the legal system still protects trade secrets as valuable information. They just have to be a little creative in lawyering with different causes of action, but trade secrets are still highly respected and valued in Singapore.
And then what about this Hawaii case?
Yeah, the Hawaii one is interesting. First off, it's in Hawaii, which isn't normally a hotbed of IP litigation, but this is from 2022, and it's also a really unusual situation where an employee moved from the continental US to Hawaii to join a real estate brokerage company. And they had a non-compete, but it was really unusual in that the employee could leave and join a competitor, no problem, but they couldn't start their own competing shop, which is, I've never ever seen before that someone would split those two. They're always prohibited together. So of course this person left. Of course they set up their own shop, and it came back to this idea of what's the legitimate business purpose, and again, it was protecting trade secrets. And here the difference that the court looked at was how well did the first employer protect trade secrets in the first place? And what they found was it was very random. Some employees had NDAs or other confidentiality agreements. Other ones had nothing. And there was no program, there was no policy. It was just total randomness. And the court said, even for your existing employees, you're not protecting your trade secrets. So why should we require your ex-employee to do any better at protecting your trade secrets? And ultimately, the individual succeeded and launched their own real estate company. But it was interesting on a lot of different levels. The location and the fact that they split the difference where you could join a competitor. A pre-existing competitor is fair game, but launching your own shop is somehow a bad thing. And it really kind of smells of anti-competitive behavior. There's always kind of that overlay or lens of being anti-competitive with non-competes. Great story if you want to read it.
It's awesome, and I think share the common common thread of you weren't doing some of the basic blocking and tackling, right? And
that's right.
This stuff's not that hard. John, did you want to touch on any of the EU cases? I know there's this Hinton SEI case as well.
Yeah, a couple of cases. The Hinton case was interesting because there seemed to be a fear in that case, and the two sides were playing the game to try and reduce the likelihood that they would have to reveal confidential information to demonstrate that they had it, that it was exposed to the employee, and that there was a risk of him taking it. So again, That's a big concern, and clearly, I would imagine in a trade secrets case, you could get an expert in to attest that it were actually there, it did exist, and it was secret, etc. But yeah, so that was interesting. And then in the other case, which was a Plan-On Limited versus Gilligan in 2022, reading here, the Court of Appeal ruled that a court will not automatically grant an injunction for a restrictive covenant and non-compete, even if it is on the face of it enforceable. The court also noted that the High Court is not able to consider whether a restrictive covenant, non-compete, is enforceable when deciding on an interim injunction. So, less power to the non-compete in those two cases at least. And then a further case, Quilter versus Falconer, went down, as Chris has sort of alluded to, well, in specific examples, duration, geography of the restriction, nature of the employer's business, and the employee's role within the company, then it possibly could be enforceable, etc. But those factors will have to be met, of course, for it to work.
So we'll jump into trade secrets in 1 minute, but just to kind of tie this off, I don't want to leave here thinking trade secret or non-competes are dead. Don't worry, just head over to trade secret land. I get the sense that these non-competes should be part of a holistic IP strategy, right? And they should be crafted to be enforceable. So therefore, where are you located? What's the language? What can you actually enforce? And so, look, I think these are still very important agreements. But I think as probably at least, many of these cases that you two just talked about speak to, is that even in a non-compete litigation, you're going to need to sort of point to the confidential stuff, right? And so then that's where it's totally blurred the lines. It's looking like a trade secret case. And so you got to do the work, right? And so let's talk about doing the work. John, I know a lot of your life and practice now focuses on this topic of trade secrets. And so maybe just talk a little bit about what life looks like for you when you jump into a new client engagement. What's a typical client look like for you? How much disarray is there? I would say anything that you could tell us about the experience of going from zero to a trade secret program would be super useful.
Yeah, great question, and of course it varies very much, and of course none of us want to be called in where there's been an issue. We much prefer to be consulted where there's a proactive approach and people recognise there's value. And so I much prefer being involved in the whole strategy. So what back to your question just there, what is the whole IP strategy? Well, it's multifaceted. We're not going to rely on any one form of contract protection or intellectual property protection. We're going to go multifaceted. So yes, we will look for non-competes with employees, possibly company to company, but likewise, we're going to look at patents, but in conjunction with trade secrets, because of course, we really value patents, but they're not ultimately to be relied upon. So you need to bolster that all with trade secrets. And so it's really, what I love about it is the sort of voyage of discovery and the process, building that process in whereby the R&D team starts to identify valuable information, innovations, potential patents, potential trade secrets on a regular systematic basis, because then just so by doing, you're building that culture in the business. And once you've got that culture in the business, it's self-fueling, right? Because they're recognizing the value of IP, they're recognizing the different forms of IP, and they're able to identify it, value it, protect and manage it. And that's what this is all about. But ultimately, as you know, it's about training, it's about culture, it's about process and policy, and it's about having a decent register to populate as part of that process, to have something to put. And you know, the key for me is to try and make this as seamless as possible, as low, what's the word? It's not low touch, is it? But low impact as possible. It's not, you know, try and make it as business as usual as possible, because the biggest fear for people, in my experience, is, oh my word, it's going to be a big new program. Oh no. So yeah.
Actually, John,
No.
on that topic, I got a great question. David Boslin. Hey, David, thanks for joining us. To get a client to move on something that may be a new space for them often just requires that first step. Do you have a go-to first step task that I might encourage my clients to take? That's an awesome question. So I've certainly got some thoughts on it, but John, I'd love for you to go first. What any words of wisdom?
Wow, that's a big, you know, maybe I'm going to ping that one over to Chris, but there's so many different reasons why that people get to trade secrets. Some of it is recognition, some of it is just valuing what they've got in terms of know-how and expertise. But yeah, I'm going to defer to Chris, and I'll think about that. I'll take my 5 minutes and phone a friend. Go on, Chris.
I'll try to stall as long as possible, John. To me, the first step is training and education. And tangibly, we always talk about that. Yeah, if you can take your client or your coworkers and get them to know what trade secrets are, to understand why they're valuable, to know how to manage them properly, or at least not improperly, that pays tremendous returns on your time and effort investment. And then you can go into things like designing a program, identifying trade secrets, cataloging, or otherwise understanding what you have. But to me, really, if you had to do only one thing first, it's training. It all comes down to getting people to know and appreciate this relatively new kind of IP that most people haven't historically thought about.
So, Chris, let me add. So, I think once you kind of make the mental leap, we need to go do something. And so, let's imagine, training. You've got an in-house counsel that's done a little bit of training. What we see all the time is, okay, now what? Like, what do I do? And maybe I'm a bigger company, let's say, and it feels a little intractable because we live this every day. I'm a Fortune 100 and I'm doing nothing, right? What do I do? Where do I start? And so I think there's a few different ways to tackle it, and from a company culture, specific, say, well, as a group of IP leaders, what do you think the most vulnerable stuff is, right? And so sometimes these kind of questions can just zero you in on the high value. Right. And so it's like, well, first and foremost, maybe let's go tackle high value stuff. Right. You may often find that high value stuff's already out in the wild because it's been shared with a supply chain partner, for instance. Right. So always find that, like, if a client or companies have a little indecision about, do I even have trade secrets? I always find a good conversation is, well, let's talk about your partnerships, right? What do you share with your partners, right? Almost 100% hit rate. They can go, like, light bulb goes on. They go, oh yeah, we share whatever, right? And it tends to be pretty high value stuff.
There's lots of ways to make it more manageable. And you're right, especially when we meet with medium or large size companies, it feels really difficult, and it's easier to do nothing than take that first step. And I always use the joke about, how do you eat an elephant? One bite at a time is the right answer. And trade secrets are the same way, where at first it can be really intimidating and scary. But if you find ways to break it up, like look at the higher priorities, or maybe based on certain projects or certain geographical sites, suddenly it becomes much more manageable.
John, any ads? No, lots of different examples. I was with one company, and they said, well, we don't really have any trade secrets. No, we don't really have any competitors. And we asked a few questions, and we got to a few, and it turns out that the delivery guy was always in demand. The delivery guy who also served their competitor was always in demand when he arrived, because they'd always go have a chat with him and see what was going on at their competitor. What's new? What are they doing? Oh, they've got a new plant. Have they? How does that work? And I said, well, what's happening in reverse? And so those sort of things are quite funny. But I think the point is, a lot of people start out thinking they don't really have that much, and then when you start to do the work, it becomes, very quickly, well, there's 100 that you didn't think you had, and here are the categories, and it's quite interesting how quickly that can build up, and how people start to recognize the value in what they didn't recognize previously. So training, the process is really important. Fitting into Confluence or whatever system they have in place already, and then a process of reviewing and evaluating the information as it comes through, and of course it's always top secret until it's deemed otherwise.
Exactly, everything.
Yeah.
So I think that last point, John, is a really important one, which is, and I probably can't state it strongly enough, that policy, if I think we peel it all back, and I don't know if this necessarily talks to David's question, but like, do you have a trade secret policy, right? And one of the things that we're coming out with, and some new features, is just walking you through a set of like real easy setups, right? So here's your trade secret policy if you don't have one, right? Take this one to your lawyer and tweak it to make it perfect. And then like an AI policy, like those two things. Do you have a trade secret policy? If yes, great. Do you have an AI policy yet, or an LLM policy that talks about what people are allowed to put into the systems? Those two things, I mean, the LLM policy, like in my mind, is almost the most no-brainer topical thing we can talk about today in terms of risk. And so be policy driven, because at the end of the day, that's going to define your culture as well, right? Which is to say, hey, this is what our policy says. We're going to, check in every 6 months or every 3 months or whatever the number is. Almost doesn't really matter. But if you don't have something guiding you, inevitably you're going to be, flying by the seat of your pants. So I'm a big fan of policies.
My understanding is that some of the general insurance, business insurance, cover trade secrets. But because of the rise in litigation, they're introducing and pushing hard on exclusions, and the exclusions are such like, do you have a policy? Can you demonstrate it's enacted with it? People are engaged with that policy in your business. Do you have a register? Can you demonstrate that you're actively using and capturing trade secrets within the business? Are people trained? Can you demonstrate that they have a good level of understanding of what a trade secret is and how to treat confidential information? And if you can do all of those, then these, not specific trade secret insurance, but general insurance will in theory cover your trade secrets. So I think those, it's very clear that if that's what the insurers are asking, and it seems they are, then those are probably the three key things that the businesses should be looking at. And then of course the first one is, did it exist in the first place? And can you demonstrate that you've actually captured it? But I think that illustrates the point extremely clearly from my perspective, at least.
Yeah. So, and I think I'll put a couple links in the chat here, for folks, just some good reads and touch on this topic. But Jim Pooley actually wrote a good piece in IP Watchdog. Chris actually had a nice piece on our blog as well that kind of speaks to sort of the importance of policy when it comes to this topic of like not missing the trade secret, right? And so one of the things we often hear is like, well, my gosh, if I start cataloging my trade secrets and I miss the one, what am I going to do, right? Like I'm totally screwed. And I think that's where the policy is your saving grace as well, right? And so, and I think one of the things that Jim points out, and that we've talked a lot about is that you're not striving for perfection, right? And you're gonna have a process, and if I miss that one, I've got a process to go try to find it every 6 months or whatever, right? And so I think this is not rocket science. This is just sort of good practice and good hygiene. So.
Yeah, and Tim,
Well,
I want to be sensitive to time because
Oh,
we're
yeah,
almost at the top of the hour. But
yeah,
I don't want any of our viewers to think that non-competes are dead or useless. I mean, they're still an arrow in your quiver. Maybe they're not as reliable or as predictable that they would hit the target as they were before. But it's still worth having them and have them be tailored to the situation. The other thing is a psychological impact. So a non-compete is a psychological deterrent for the employee, which might have some value to you as part of your holistic management plan around IP. So I just want to make sure that people watching don't think that they're completely dead and have no value, because they still do. They just aren't as silver bullety as they used to be.
that's right. Yeah, I think John's point about real IP strategy. I think one of the things we just so often see is shoot from the hip. I file some patents. I don't know. I've got some NDAs or something, and I should be good, right? And I think like pretty much you don't have to look too much further. And Chris, maybe we could just talk about Zunum real quick. There's been some very important cases, trade secret cases decisions over the last like even couple months that sort of point to this idea that details matter, and having trade secret documented matters. And so with Zunum Boeing, Chris, any thoughts on that one real quick?
Well, and just very quickly in the last few minutes, Zunum is a perfect case showing the trend, which is courts are requiring more and more specificity and less hand waving than ever before. And it's to the point now where millions of dollars, or tens or even hundreds of $1 million are being given and then taken away just because you weren't very good and your policies and procedures around trade secrets weren't strong enough years before you even had a problem. And Zunum is a great case of the everyone got really excited, and then later on all that money went away because the trade secret owner wasn't specific enough, and it wasn't labeling and cataloging and all the things that we talk about, and it can really change your fortune.
Yes, it can. One day you have 72 million bucks come into you, and the next day you
The
don't.
next
So,
day it's gone.
oops. John, any parting thoughts? I know we're down to the last few minutes. I'm going to post a link to a LinkedIn post that I made a few weeks ago about this other case that we're going to talk about. But it's worth reading the judge's language in that one. And so, John, any parting thoughts here?
No, just echoing what Chris has just said there, that in my perspective, you can't rely on any one form of contract or IP. You have to have a blended approach and several legs to the stool, and that puts you in a much stronger position. So that is, as you say, NDAs, contracts, non-competes, but also patents, trade secrets, trademarks, designs, etc. You need the full gamut of support in order to withstand any attack, but also to be able to enforce your rights and extract the maximum value from your intangible assets and your intellectual property.
Awesome. Chris, any parting thoughts?
No, just that these are really exciting times for IP in general and trade secrets specifically. There's a lot of interesting questions, and as technology and work patterns change, the law struggles to keep up with it. And it's just a great space to be in.
Awesome. I see a few more comments here. I just want to say hi to Joel, Jim Larson. Thanks for joining us. Great to see your name there. And we got a nice comment from Dr. Thomas Murphy talking about some historical stuff that's happened at DuPont. And so some of these concepts hit home there. I think with that, guys, this has been a great first stab at a LinkedIn Live. John, thanks a lot for joining us. Really appreciate all the work that you do to bring awareness to the community, and love being a partner. Chris, thanks for joining us. Good luck at the conference today. You're off to lead a roundtable in another hour from now, and if anyone wants to contact any of us, there's our info. Just drop us an email, LinkedIn, direct message. We are happy to chat trade secrets any time of the day. So thanks, everyone.
Thank you.
Thanks. Bye now.